Bună ziua! Cred că putem începe.
Good morning. I think we may begin. I am Olesa Garbus. I'm coordinating projects at Freedom House. It is my special pleasure to greet you all here, and thank you very much for being interested in this event. The four-feature institution in the Republic of Moldova, existing interpretation initiatives to amend legislation, and the extended four-feature mechanism of assets which had been accumulated by corruption. This event had been organized in partnership with the Center for Preventing and Controlling Corruption within the framework of the project Citizens Speak, promoting democratic reforms for the interests of the citizens of Moldova, which is supported by the United States Department of State. At this event, we have simultaneous interpretation into Romanian and into English, and the event is also broadcast live on our live and on social media. This is one of the last public events organized within the framework of this project, and I take this opportunity to thank the entire team of the CIPC for this cooperation. Now I would like to offer the floor to the chairperson of CIPC, Galina Pascan, and she will share with us more details about the today's event. Good morning, everyone. Today we have this roundtable entitled the Four-Feature Institution, the Republic of Moldova Interpretation Initiatives and Practices in Application, and as an incentive to organize this roundtable, we have had the legal initiative of the President of the Republic of Moldova, which has been made public at the beginning of February on amending and complementing Article 106 prime of the Criminal Code, which, as far as you know, regulates the institution of extended forfeiture. We have developed an opinion about this legal initiative, and therefore I will present on the first, on the one hand, the ideas with regard to this legal initiative, and on the other hand, our opinion on the new regulations which had been proposed. So, as I have mentioned, at the beginning of February, the President of the Republic of Moldova has put forward a legal initiative on amending Article 106 prime, and besides 106 prime extended forfeiture, we also have amendments to Article 330 of the Criminal Code, and the initiative in particular refers to the amendment of paragraph 1 and 2 of this article 106 prime, and this is about extending the range of offenses which are subject of this norm, and also on amending conditions when to apply extended forfeiture. These, and on top of these, there were two additional paragraphs added, and I will definitely refer to the contents of those two paragraphs which were added. So just as a general observation, every time we are reviewing a draft law, then every time we pay attention, special attention to this background note to understand what was the driving force of these amendments. We know that 106, this article, the institution of extended forfeiture, had been introduced in 2013. So since 2013, we have this provision. This was drafted and then introduced in order to enforce legal provisions provided for in Pillar 4 integrity of the justice actors of the action plan for the implementation of the justice sector reform. And we also know that there are certain elements which from the very beginning had been thought through for this institution, and we cannot identify them in the background note, which has been presented by the Ministry of Justice when this the institution of the extended full feature had been presented. That was a very clear background note. And moreover, this institution, the extended full feature institution, as it is regulated in the criminal code, in the current reading of this code, this has also reviewed by experts, foreign experts, which did not have objections in relation to the institution of extended full feature. Now, as regards the background note and actually the arguments for that note for amending Article 106 prime, and the declared objective of this initiative, of this legal initiative, had been that the draft law has been developed in order to remedy legal gaps or imperfections and the provisions of Article 106 Criminal Code. The background note or the argumentation note aims at or explains that the purpose is to amend our paragraphs 1 and 2 of Article 106 so that it would be possible to apply in practice the mechanism of extended forfeiture. When we analyze a draft law, we start with what the purpose of this draft law is. And starting with the declared goal of this legal initiative, we would have expected the author to provide arguments for these statements. However, they were not really there. And at the same time, we have found that there had been at least two surveys which look at the analysis or analyze the institution of extended forfeiture. That is an analytical survey on the mechanism to recover and forfeit the criminal assets, which was commissioned by the UNDP within the framework of the project Strengthening Capacities of the National Anti-Corruption Center for Analyzing Corruption. I need to say that this survey had been developed before the Criminal Assets Recovery Agency had been established. And there was another alternative report on applying or enforcing Chapter 2 and 5 of the United Nations Convention on Corruption, which was entitled Fighting Corruption and Recovering of Criminal Assets in the Republic of Moldova. And this has been drafted by our organization several years ago. It's important to bear in mind that none of these surveys had referred that we did not look at the regulatory issues. I mean, according to these surveys, there are no issues from the regulatory perspective. However, the analytical survey on recovering and forfeiting criminal assets in the Republic of Moldova has looked at the following problems on forfeiture: insufficient mechanisms for coordinating coordination and exchanges, insufficient knowledge of investigative techniques, financial investigation techniques, mechanisms to manage the inadequately seized assets. And there's no issue with regard to the regulation of the confiscation or forfeiture institution. We thought that all the arguments with regard to the issues of regulation or regulatory issues could be raised or could be identified from statistic data. However, the author hasn't presented anything in this regard, and there has been no information on implementing this after the entry into effect. So normally, since the institution is already effective and applicable since 8 years, we should have looked at the practice of how this institution applies, and we need to understand where the problem lies. But nothing has been presented. So the information from the information note to the draft law represents some assumptions which had been developed by the author and which do not seem to be connected with the practices in the criminal justice. As regards statistic data, there were no statistic data on the number and extended for features applied. The criminal cases were extended for feature had been mentioned. The types of subjects in relation to whom this extended full feature had been applied. This statistic data would have been useful for the financial and economic grounds of the project. Since there's no such statistic data, the draft authors had to provide information on the number of cases when the extended confiscate or forfeiture had been requested. The types of the subjects in relation to whom this forfeiture had been requested, the reasons why this has been requested, and so on, so that we understand why extended forfeiture does not work, why it does not apply in the current regulations. All this information is not there, it's missing. At the same time, and a general objection is refers to the extension of the circle of crimes or offenses in relation to which extended forfeiture could apply, and or other actions where the revenues or the damages could be prevented. We believe that this provision could generate multiple abuses in the future, in particular from the criminal prosecution bodies. So this background note does not have information about the economic and financial arguments, and otherwise this draft proposal would definitely influence the amount of the financial flows and the revenues to the budget. And it would be good to estimate the number of persons or the means which would be subject of the management or the forfeited assets and so on. Another overall information would be that the draft law is not regulated from the perspective of the impact of this initiative on the entrepreneurial activity. Given that the extending the range of offenses, this would also apply to tax evasion and unfair competition. And now to look at the objections. So we have mentioned that Article 1, the proposal on this provision actually, or paragraph 1 actually has provisions on the extension of the a range of crimes in relation to which this extended forfeiture could apply. And this, besides the actions provided for in this regulation, while it implies that this extended forfeiture would apply also in the case of blackmail, fraud, tax evasion, and unfair competition. Well, we believe that the expansion of the circle or this range of offenses is not timely and is not necessary. And the main arguments are, first, the component of offenses which are quoted in the current reading of the Criminal Code 106 covers the range of offenses of the directive, EU directive on freezing and forfeiting the outcomes of the criminal actions committed in the European Union. The second thing, I mentioned the alternative report or the shadow report does not identify any issue with regard to the ones that are provided for in the current regulation, and the extension of the range of offenses in relation to which extended forfeiture could apply, and other actions where the revenues and the damages are determinable. This is abusive. Well, this rather refers to blackmail, fraud, tax evasion, unfair competition. In case of tax evasion and unfair competition, the authors should have presented information on the impact of this proposal on the entrepreneurial activity, including in the context when the tax service has already mentioned to acquire criminal prosecution competences. Here, I would like to underline that for a number of years, we have promoted the idea of removing this competence of criminal prosecution from the tax service and the customs service. However, still and again, these authorities have acquired or have acquired criminal prosecution competences. Well, we need to have clarity as regards the institutions which have competences of criminal prosecution bodies. And another argument is the circle or the range of people in relation to which the extended forfeiture could apply. This is dangerous from the perspective of the amendments to the punishment with imprisonment, because that might lead to increase of corruption, at least among the criminal prosecution bodies. And lastly, the extension of the range of offenses as such, this does not address the issue of practical implementation of safety measures, including when there's no very thorough analysis and statistical data also. And here I'd like to draw your attention to offenses such as tax evasion and unfair competition. I believe that such a provision would very much cut from the appetite of our citizens in general to engage in entrepreneurial activity combined with the competences given to the state service of criminal prosecution body that might have an extremely negative impact on the entrepreneurial activities. Maybe they could present the authors could present the types of violations or offenses to justify such an extension. But since we have nothing like that presented, we believe that this amendment is abusive and would, on the contrary, create multiple issues. As regards paragraph 2, the proposal in paragraph 2, which reads, well, which specifies the condition of 20 average salaries per economy. And there is another proposal, but this proposal in principle complies with a recommendation of the Constitutional Court. And there is a proposal which most probably concerns or bothers the author of this draft. I'd like to quote, this refers to paragraph 2, letter B, and I'd like to read from the argumentation note or the background note drafted by the authors. So, So the imperfection of the norms provided for in Article 106 prime, which makes sometimes difficult and sometimes even impossible to apply extended forfeiture of assets, results from the provisions of Article 106, paragraph 2, letter B. As mentioned earlier, to apply extended forfeiture, it is necessary that the person is convicted for an offense provided for in paragraph 1 and the committed for material interests. So, and in addition to this, one of the conditions provided for by Article 106 prime of paragraph 2 to be able to apply extended forfeiture, it is necessary that there is a substantive differences between the worth of the assets obtained by the convicted with the licit assets obtained by this person. So it is not clear that that there is a need for a third condition, at least as provided for in Article 106 prime, paragraph 2, a letter of the Criminal Code. The court finds, based on the evidence attached to the file, that these assets come from criminal activity as provided for in paragraph 3. The statement when these assets come from criminal activities as provided for in paragraph 3 actually impose the court to establish, when applying extended forfeiture, that each forfeited asset comes or is a result of an offense. So the author actually believes that this is the biggest issue, which impedes the effective application of this institution of extended forfeiture. I need to go back again to the background note, which has been presented by the Ministry of Justice when in 2013, when this provision had been put forward. And I will read again from the background note of 2013, which explains very clearly how this provision would apply. On the basis of the provisions of the new Article 106 prime of the Criminal Code, the prosecutor would have to prove only one person in a certain period of time that this person had been involved in committing certain offenses. From that moment, the judge could presume that the assets obtained are the result of offenses committed by the convicted person within the framework of a period of time prior to the conviction, which is considered reasonable by the court. So this assumption, it would mean that the convicted person would have the burden of proof to prove that the assets are licit. If the judge believes that the amounts obtained or the worth of the assets obtained are too high as compared to the licit or legal assets, well, it's really clear from the very beginning that this norm provided for by Article 106 prime had been put forward, had been proposed for approval. So the objections our organization has, well, our recommendation was that Article 2, or paragraph 2, sorry, of Article 106 would be revised by amending all of that, except for the specification with regard to 20 average salaries per economy. And we have argued that and this is not timely because the formulation of the text does not comply with has not been in line with the provisions, legal provisions, and that the text is not in line with Article 96 Criminal Procedure Code, which reads the circumstances that need to be proved in the Criminal Code, and Article 101 of Criminal Proceedings Code, which looks at or implies at the provisions or the provisions on the evidence. And we also believe that this text does not successfully reflect the principle of the evidence of Article 97 of Criminal Proceedings Code. I mentioned that the author of this draft had has supplemented this article with 2 more paragraphs. So Article 2 prime, which reads that extended forfeiture can be can be applied, including when a suspect or a convicted person for committing a crime provided for in this article, and the person has died, or if the person hides from coming to court and does not come to the court. And we need to see that the distance of several paragraphs, the draft law author forgot that the extended forfeiture applies only when there is a convicted person. So the person needs to be convicted first. We can't speak of an accused person or of a suspect. The recommendation was to remove paragraph 2. At the same time, we mentioned that this proposal contradicts paragraph 1 of 106 prime, and we also draw attention to the fact that the criminal law does not operate the notion of accused or suspect. Using the person of a culprit, and we have made reference to Article 63 and 65 of the Criminal Proceedings Code. Another paragraph that we propose to add to the institution of forfeiture is paragraph 2, the second, and this reads that extended forfeiture can apply to assets which are transferred to third parties if they knew or they were supposed to know that the purpose of the transfer was to avoid forfeiture. We have proposed, recommended to remove this paragraph because this norm actually repeats the provisions of Article 3 of 106 prime of Criminal Code. And finally, we have proposed to supplement Article 330. Well, actually, to replace the wording exceeds 20 average salaries per economy from the legally obtained means. Well, we have assessed that this amendment is in line with the ruling of the Constitutional Court of 2015. At the same time, we would have to coordinate the exposure of the contents of this proposal and coordinate this with the exposure of Article 106, paragraph 2. So to conclude, we have shown that this draft law amending the Criminal Code of the Republic of Moldova in the version proposed by the author is not justified. Therefore, promoting its whole version is not appropriate, and therefore we believed that this specification, this 20 average salaries per economy and Article 330 is totally justified by the address of the Constitutional Court of 2015 and should be promoted. And this was the opinion of our organization with regard to this legal initiative. And now I would like to open the floor for discussions. And I would like to offer the floor to Mr. Victor Strato, head of the Division for Drafting Normative Acts of the Ministry of Justice. Mr. Strato, you have the floor. So there was an issue with his connection probably. So I have a hand. I see a hand raised by Mariana Kalugian. As far as I know, Transparency International has also presented its opinion on this a legal initiative, and I would like to invite Mariana Kalugin to take the floor. Thank you, Galina, very much for this opportunity to speak about the opinion of the Transparency International Moldova on this draft law. The opinion of Transparency International Moldova can be seen by accessing the website. And in general, we have mentioned that the efficiency of these it is absolutely necessary to regulate the extended forfeiture and illicit enrichment, because this law does not imply efficiency of these norms. And moreover, there was a number of problems issued. So first of all, we have drawn attention to the fact that these subjects with the right of legal initiative have to respect the limits provided for by the law when they promote a draft law. And to support this this initiative, we have provided for articles 106 prime on normative acts which need to be met in order to initiate a draft law, so that these are initiated within the limits of the competences of the authors of this initiative. In our case, this draft had been initiated through the light of the provisions of Article 77 of the Constitutional Court. So the president, it was initiated by the president. It is the represents the state, and the Constitution of the Republic of Moldova provides exhaustively in Article 87 and 88 the duties of the president of the country in the areas which are delegated to the president. So we believe, looking at the contents of the draft, which refers to Article 106 prime and 332nd of the Criminal Code, the regulated area is the competence. And according to points 6, 9, and 15 of the regulation on the organization and operation of the Ministry of Justice, or the internal rules of procedure of the Ministry of Justice, approved in 2017, the policies, state policies in anti-corruption, are competence of the Ministry of Justice. And we still believe that these draft laws would be developed more efficiently if the competence limits would be respected. And when we have projects which are specifically relating to the encoding of norms on corruption, integrity, it would be preferred that these are promoted by the well, another aspect that I have insisted on, and we have this as a systemic issue, the draft needs to be announced in line with the law on normative act, because that reads that the lawmaking process also would imply the publication of the announcement on drafting this norm. And the respect of these provisions is very important, because this is very important for the decision-making process. And the web page of the President of the Republic of Moldova does not have information that would convince us that this stage of the process had been respected. And as far as we understood, this draft has not been consulted with the authorities which are responsible for the enforcement, and that is very important. we believe that when it is about such projects, it is really important to listen to the opinion of the practice. And this is about the integrity of the NAI. It's about the National Integrity Agency, the integrity of the criminal prosecution officer. So without their opinion, this draft law should have not been promoted, and otherwise we couldn't observe that the presidency of the Republic of Moldova has not published internal rules of procedure, and on the website there is no general list of stakeholders or the information on the person responsible for that, or reports on ensuring transparency. So for instance, and even if the parliament cannot always provide examples of good practices, we observe that, but the presidency of the Republic of Moldova is lagging behind as regards the development of institutional mechanisms aimed at ensuring decision-making transparency. We believe that this draft is not sufficiently argued, and I would like to go back to this note that such a draft law, when it comes to the criminal code in particular, and to amending a offense competences without a fundamental analysis and professional analysis, this no draft law is justified, or it could lead to a punitive practice, and the punitive practice, criminal practice, doesn't only actually profanates this institution. And we have also mentioned that there should be discussions about the extension of the enlargement of the extended forfeiture mechanism. And in case of tax evasion and unfair competition in relation to convicted persons, and the draft in this regard should have been preceded by a regulatory impact assessment, because an enlargement in this regard would discourage the business environment, let alone that, honestly speaking, the application of this to legal entities seems to be difficult. If we look, for instance, at the correlation between the properties and assets and revenues, sorry, which seem to be okay for these people, this becomes a problem if we look at these persons. And moreover, we believe that the project should have been reviewed by experts from the perspective of its compatibility with the EU legislation, or the authors of the draft make a reference to a document of the EU directive on crimes or offenses committed in the European Union. And here, all these requirements which are applied in this regard need to be respected. And this case is complete when from this draft there were all documents, absolutely all documents which are needed to, like opinions and that need to be attached to this draft, have not been provided except for the information note. So we believe that this is a difference, and we believe that this draft has some conceptual issues, and has issues with some constitutional provisions, and in cooperation with the Constitutional Court case law. And it is important to know that this opinion has been given before the decision of the Constitutional Court of 2022, number 7, where the court has provided its case law and decisions in 2000 on the cases of 2011, 2015, but in this notification or this opinion, there was reference made to some findings of the court, which, as far as we understand, continue to be applicable. And summing up the findings of the court in relation to the provisions of Article 46, paragraphs 2 and 3, we have concluded that the forfeiture of assets represents the cumulative three conditions. Only assets that have been used for committing a crime, or assets which resulted from a crime, and there should be evidence provided in relation to the assets to be subject to forfeiture as a part of this illicit enrichment, and the burden of proof is exclusively with the state bodies. And this means that this draft, to our opinion, would not facilitate, as the author would like, would not facilitate criminal prosecution of the criminal, as according to the procedures of to the provisions of criminal code. And therefore, we cannot apply the extended forfeiture instrument. And we have also noted that the draft has some issues from the perspective of technical lawmaking techniques. And in this period of time, we have also made some recommendations which have been submitted to the CAPC on this draft law, but also we have submitted this to the General Legal Division of the Parliament, and we have aligned to this. And we have agreed that exceeds 20 average salaries per economy, which is proposed to be substituted by substantially exceeds the obtained means. And this is discussed, this is to be discussed. And this is because in the first place, the law does not use the notion monthly average salaries per economy established by the government decision, which is in effect when the offense is committed. Otherwise, I have noticed that 106 prime paragraph 2 letter A, it has 20 average salaries per economy. I understand it's probably about statistic data, which it tells you how to calculate, and there is some statistic data. And this is about statistic data, or this is about the salaries on the forecast of these assets. And then otherwise, we have also noticed that in Article 206 of Criminal Code, there is a value exceeding 20 average monthly salaries per economy, which are forecast as large scale or large proportion. We believed eventually that this should have substituted with a substantial difference and or exceeds substantially the obtained means in large proportions, so that there is compliance with the criminal code provisions, let alone that this should have also included so that the same law, the same spirit is kept of the law, just to keep the notion of substantial difference which is operated when personal interest and assets are declared. When there are 20 forecast monthly average salaries consist or represent substantive difference, while the criminal code reads that this would be large proportion. And here it's we need to see what means considerable, large proportion, substantive difference, and so on. And for us, yeah, we need to make to bring all these in compliance so that the lawmaker would have a balanced, clear opinion and position on these. Also, what we have taken out, and this is also about the paragraph 2 prime of Article 160. According to Article 275.5 of Criminal Proceedings Code, criminal prosecution cannot be performed and would be stopped if there is, if the offender has passed away, except for the case of rehabilitation. And in this also says that the death of the culprit would be a reason to stop the criminal prosecution in line with provisions of Article 391, paragraph 1, line 2. And that would mean that the criminal prosecution bodies, through coercion, would have to try to succeed applying punishment to those who are still alive. We also understand very well this important line of fighting corruption. We understand that in these could also have certain norms and other norms than those applied to general cases. And however, we would like that certain provisions and some guarantees of a fair criminal process are implemented. And to conclude, we believe that 332nd, 106 prime, they all yeah, but it's also certain that another instrument it has to be applied in line with the this. So the and the case law of the Constitutional Court would not mean that we have resolved all the problems. And for us, it is really important that this needs to be done with the application of, because there are very many issues, because the notion of assets that are operated by Article 106 prime is not defined in the conditions of the criminal legislation. Or if there are two instruments which overlap, and this is apply the illicit enrichment, and another one is the forfeiture, and to what extent when there is a defined range of persons and as declared in line with the law on declaring assets and personal interests. And so we believe that things somehow should be clarified, but our proposal is that this should be done with the engagement of the so that we could come back with an opinion on the draft law, which would be comfortable not only to the authors, but also to the other members of the community. Thank you very much for this intervention. Actually, looking at listening to that, I have convinced myself once again how important this is to ensure a participatory process. But we all need to understand that the discussions on important legal initiatives represent an important factor to increasing quality of the lawmaking process. Now I would like to offer the floor to Maria Strula, head of the division and research of the Constitutional Court. Good morning. I was happy to hear that you have referred several times to the case law of the Constitutional Court, and that means that this is looked at and studied by those who are interested in case law. Well, from what I've heard today, I had this impression that there is no difference made between the standard of the proof on the one hand and the burden of proof on the other hand. It seems that these two should not be mixed up. Or if the burden of proof says or speaks about who needs to prove certain things, then the standard of proof there are certain terms or certain standards on the quality of evidence. And however, the new case law of the Constitutional Court brought some clarity in this regard as well. Although today we have mentioned the recent case law of the court, I would like to highlight certain aspects which could be essential in developing draft law on forfeiture, as well as on eventually on giving opinions on existing drafts. So looking back, we need to recall what has been mentioned today, the two previous decisions. The decision of the Constitutional Court of 2011 of Article 46, paragraph 3 of the Constitution made the application of a forfeiture, it had to be in relation to a criminal case. And that suggested that actually the application of the proofing standard is the one that is applied in criminal cases. In case of the decision of 2015, the Constitutional Court has sustained that the forfeiture applies only when there are crimes or contraventions committed, and in dubio pro reo is a corollary of the presumption of innocence. In 2022, the court has looked at the recent case law of the European Court for Human Rights, and this somehow determined the court to review its case law from the previous decisions. And in such a way, these two are opposable. The arguments of the Kogitidze versus Georgia of 2015 are opposable and more recent than the amendments or the completions to the criminal code that operated since 2013. And in case of Kogitidze, the court sustained that there are legal standards, European and both European and universal, which encourage the forfeiture of assets related to severe crimes without a prior conviction. And that is why the burden of proof of illicit assets, which are assumed to be illegally obtained, has to be or can be transferred legitimately to defendants in non-criminal procedures. Therefore, forfeiture can apply not only to results of crimes, but also in case of assets which are obtained and other indirect benefits. And in the same case, Gogetice, what is important to conclude is that the European Court made a clarification on the one hand, proving beyond any reasonable doubt, and on the other hand, the prevalence of evidence. In the decision, the revision decision of the court, we find the same line of argument. The reasons which have been subsequently found in the notification of 15th of March of this year of the Constitutional Court. And I need to underline that the court has made a clear distinction between criminal and civil procedures on forfeiture and has made difference or highlighted two standards: standard of proof beyond any reasonable doubt. And what it is very well developed in the case law of the Strasbourg Court. On the other hand, the standard of the balance of probabilities. Therefore, in civil proceedings, the standard of proof is lower than the standard of proving beyond any reasonable doubt, which operates in criminal process. So this standard of the balance of probabilities in civil procedures implies that the courts would see that as a fact is obvious only when, or is proved only when they are convinced that the possibility that this has happened is bigger than the probability that the fact has not taken place. But of course, this would have to be made only through an argumentation and by assessing the evidence which exists. I also would like to highlight the opinion of the Venice Commission, which in 2010, in an opinion that referred to a draft law of Bulgaria on the forfeiture of illegally obtained assets, has underlined that the civil forfeiture systems are created to ensure that the amounts relating to criminal revenues are proved on the basis of standard of the balance of probabilities. It's not in line with a standard of proof beyond any reasonable doubt. The idea, which is the basis of an assumption which can be overturned, is that for a person it's easier than for the authorities to establish that her assets have been legally obtained. So I believe somehow there is also at the level of applicability, there is a certain confusion as regards the presumptions and who needs to provide proof and whose duty it is. This is the practical element which has to be clarified. And to conclude, what I have there is a difference that the court made in its recent decision, when there should be a clear difference between forfeiture as a mechanism, as a civil mechanism, and forfeiture as a criminal mechanism. Thank you. That was all on my side. Thank you very much, Ms. Strula, for clarifying the case law of the Constitutional Court. And now I would like to offer the floor to Mr. Ion Kirtoacă, judge at the Chișinău Court, who will refer to the institution of forfeiture and the case law of the court on applying forfeiture, if it exists, of course. Good morning. Thank you for being invited and having the possibility to participate in these discussions. The fact that we address this issue today is very good. And actually, everyone present at these discussions have a joint goal to contribute to the fact that the rule of law in the Republic of Moldova operates as it is specific to a rule of law state. From the very beginning, I would like to specify that to refer back to some ideas expressed by Ms. Strula. The decision of the Constitutional Court on the 10th of March and the opinion of the Constitutional Court of 15th of March need to be looked at together as a whole. And actually our perception, those that see change this ratio, and I don't know who of our society is prepared for such a mechanism, but why it is necessary to pay attention to these decisions of the Constitutional Court as well as to the opinion is that in the first place we need to know that the mechanisms to control corruption which are effective in Moldova today have not proved efficient. And here I'd like to draw your attention to the fact that we speak a lot about the reform of justice and a real reform of justice. If we don't make changes to comprehensive changes to the legislation and we would only amend some of the articles as we did amend the article of the criminal code, we would not be successful. This is why the opinion and the decision and opinion of the Constitutional Court would be very important. And we need to approve norms that would regulate these civil forfeiture of assets. We have only criminal forfeiture. And another thing is that all civil servants, and on the basis of the activity of any public position, there are two principles. First is the integrity of the civil servant, and the second is the loyalty principle. And now the reversal of the burden of proof and the operation of the civil servants, and we have the National Integrity Agency or authority, and the draft laws would have to be carefully looked at, and the law on integrity and the law on financial statements or revenue statements, they would also regulate the activity of the National Integrity Authority. Well, we have discussed issues in relation to the National Integrity Authority, and that has had higher efficiency. Well, I hope it would have higher efficiency. At the same time, we would like to draw attention to several key issues, which are both in line with the draft on amending the criminal code. Well, in criminal matters, it would be very difficult to prove it because we have extended forfeiture and we have the European Court human rights case law on criminal proceedings and civil proceedings. The standards are very high, and I believe that this would be the main cause of the failures in this regard. And if I'm not mistaken, there was also the representative of the anti-corruption prosecution, and the statistics don't look very bright. The reversal of the burden of proof, and I mentioned this before in 2018, 2019, the reversal of the burden of proof in civil matters also applies in Romania on civil servants. And from this perspective, I see these possibilities as or these legal initiatives that have been started would aim at efficiency, raising efficiency in the fight against corruption, and not to make just formal reforms by implementing draft laws or by changing certain articles, but they would have to be much more comprehensive, and there should be a law applied on civil forfeiture of assets in criminal matters when the burden of proof, when we have sufficient proofs of the state authorities, such as the Criminal Assets Recovery Agency or National Integrity Authority, and they would provide sufficient evidence which would prove the illicit character of the assets, then the reversal of the burden of proof could apply. And then, as Ms. Strula mentioned, a person that has assets may be able to prove the illicit origin of these assets better than the state. And let's not forget about the persons acting in the private area. In private sector, we have many of us have friends and who work or who work for private companies and have assets of thousands of euros and never paid taxes to the state. And so we need to prove that to the state bodies and to all citizens, because we do have issues here. And from this perspective, you don't use orthodox means in a war. When this process, fighting against corruption, starts, of course, it's not going to be easy. And I reiterate that the key issue is that when the reform would be efficient, when we and the citizens would feel that the fight against corruption reflects in the forfeitures and increase in state budget. But as long as we have criminal cases which take years to review, tens of years to review, there are files which last tens of years where they demand extended forfeiture, of course we would not have results. We have this extended forfeiture mechanism for 10 years and there's no result. And from this perspective, an alternative to extended forfeiture reflected in the criminal code, it would be civil forfeiture, which would reverse the burden of proof. And I always give my example. Every time a person that has an apartment and so on, in the context when they can prove the origin of these assets, I see no problem to provide them to the state authorities. And I personally see no problem to explain this even to the state authorities if there is suspicion on the origin of the assets or of the apartment. And this should not be, a reason to hide from procedural aspects. Thank you. So, Mr. Kirtake, thank you very much for presenting this opinion, which is different, but it's good that there are also other opinions. In any case, this shows us the whole range of approaches that would have to be taken into account. Galina, just a second. We all here speak in favor of the will to goodwill. We all admit that there are severe problems, and in this context, alternatives or legal solutions that have been proposed now have not had any efficiency. And then what do we do? Do we do the same? No, we need to change this. We have, in 2015, I think, we have introduced the article on illicit enrichment, which is now known. Yes. So the question is, should we change this? What is the efficiency? What is the result of this? And as long as we do not hit those that have illegally obtained their revenues, or they at least do not have justification of their assets, we would not have efficiency in the fight against corruption. And in this state, we would not have integral persons because of these people which have occupied these public functions. They have become not so attractive because state does not have means to pay salaries to honest people. And then what we do, we hide behind procedural means and we protect those who are extremely rich. There is another thing, that at a certain moment, the state would not have to collect taxes from because people leave and there would be only civil servants. So the idea was a different one. It's good when there are different opinions. And I would like to offer the floor to Dumitru Obade, the head of the criminologic analysis or forensic analysis, proposals of the legislation of the criminal prosecution.
All right. Obviously, everything which was said by the predecessors, was part of the opinion formulated by us. We sent it to the Minister of Justice and State Chancery, and with a number of suggestions that Mr. Logan talked about, Mr. Kiotoka. Well, it would be okay, the statistics and the problems of applying insurance measures. This is more known to the specialized corruption offices which apply these institutes. We also come with a suggestion to review what was submitted for clearance when it comes to the problems regarding the recommendations from the European Court and Constitutional Court and the case law from 11 and 15 and 2020, the last, right? 2022. And we also talk about some issues regarding extended confiscation of the assets of deceased people. And we cannot, this is applied by the court or the prosecution without actually being able to talk about these assurance measures. And in this regard, this draft would raise questions. Now, we agree that any legal proposal, must have an empirical basis, and it's about the problem that the courts and criminal investigation offices or institutions are facing when it comes to applying the law. So it's about practical fundamentation, about us being able to develop a legal mechanism. So I'd like to state that the professional approach by the NAC and the Transparency International and the opinions are objective, they are well justified and well written. And thank you for the effort and for this platform that you are organizing, so that we could come with a proposal and to ensure this transparency, decision-making transparency. Thank you. Thank you very much, Mr. Lobada. Alexander Morkov, delegate prosecutor to from the Prosecution General from the Criminological Department. Mr. Morkov, I think he's not here. I think we will. It's just me. All right. Thank you. Okay. Let me give the floor to Anna Kushnir. She's a prosecution and the policies reform and management of projects, also from Prosecution General. Do we have Ms. Kushnir here? No. All right. Christina Rotar, Deputy Head of the Legal Department from the National Integrity Authority. So Christina, tell us that she has technical issues. All right. I'll give the floor to Vitaly Raku, Head of Financial Investigations from the Asset Recovery Office from the NAC. Hi, everyone. Ms. Kalugin raised the hand. Maybe we give her the floor. Thank you. Sure. I just wanted to give you a comment, because as I understand it, the decision of the Constitutional Court gives green light to the confiscation of unjustified assets, which can be applied according to the law on declaration of assets in personal interest, because we make a difference between civil and criminal confiscation. So Mr. Kiotoka mentioned that. So we have this already. Because even though we have until 2021, we have 25 finding documents regarding to unjustified assets. When they are already in the, some applications are in the court on the classification of unjustified assets. So far, the representative of NIA, which has remedied probably his technical problems, will tell us whether we have decisions in this regard. What I know, that there was only one decision, which is not yet final, regarding and former MP Diakov, where the application from National Security Agency was rejected. When it comes to illicit enrichment, we have 39, from what I know, 39 cases which were registered from 2014 up until 2021. Data may not be specific because they were provided by the Ministry of Foreign Affairs based on the registry that we have, and based on the fact that the authorities have not yet followed through that. And from what I know, only just one sentence against a chief of a subdivision of a hospital, but he was convicted. But besides illegal enrichment, it was also abuse. And actually, he recognized his guilt during the criminal proceedings. The problem is that, and this probably should be discussed in a different format, because we would get entangled in the jurisprudence of the court. I think that the findings of the court in the most recent decision are debatable. First of all, it's about the Georgia case. The European Court in this case started from certain findings, and in case of Georgia, the constitution is different than ours. So in case of Georgia, there is no provisions which would be similar to those which are in the constitution of Moldova. If I'm not mistaken, Article 12 from Georgian Constitution, which actually in Part 2 says that in the interest of the public, the right to property in line with the law can be curtailed. So a bit of a different situation than Moldova's case. But again, I think that maybe in a different format we could discuss the case law of the Constitutional Court. It was important to specify by me that we already have this clear difference between criminal and civil confiscation, and we also have green light, starting from the previous case law of the court to the confiscation of unjustified assets. Thank you. Thank you very much for Mariana for this. I see Mr. Kiyotaka's hand. Mariana, just one comment on my behalf. I said the following, that first and foremost, the decision of the Constitutional Court number 7 from 10 March and the opinion from 15 March, they are joint and they have to be interpreted when it comes to the creation of actually creating a mechanism, national mechanism, efficient one during the confiscation process. And I also reiterated, and I said that the standard regarding criminal matters, extended confiscation is not efficient, because this Article 106 of the Criminal Code was introduced 9 years ago in the Criminal Code, and we don't have many cases where we could have extended confiscation. Moreover, that was there's a big difference between civil and criminal. Actually, people will prefer more to have criminal cases than civil cases, because criminal cases you can delay them, criminal cases you can stop them, but when you have the inversion of the burden of proof, if we have a law on civil confiscation, in this context, the subject will have an active role and they'll have to prove their goodwill or legality of obtaining wealth. Me as a judge, and I said it many times, because there was a criticism regarding the law on preventing after it was voted, and I actually talked about it at the radio TV, at the TV and radio show. I would comply with all the laws of Moldova as a judge as they are. This one and two, and the decisions of the Constitutional Court are final and definitive, and I cannot discuss them, and I will interpret them as a judge in order to pursue them. That is all I wanted to say. Thank you. Hopefully I was understood. Yeah, look, Lina, I promise I'll not intervene anymore if it is necessary. However, illegal enrichment, meaning criminal punishment, is more severe for the confiscation of unjustified wealth, if that is ascertained. What you can apply to the public servant is the interdiction to occupy positions for 3 years. But if it's about illegal enrichment, and if you have a conviction for illegal enrichment, then you risk not to be eligible for a position, public position. That is why I don't think they will prefer illegal enrichment. They should look at whether they could occupy positions in the future. What is certain is that this discussion proves us that we will not exhaust this topic, and of course we need to discuss it once again. And my last intervention for today, I will just compare it to Romania. And Senator Țopescu was saying that Romanian politicians who were in the jail and how much they paid. Someone stayed 3 years and they have a wealth of 3 million euros. Many would want to have a criminal sentence of conviction, special confiscation, but after they are in jail, they will still have 30 million euros. That is my subjective opinion. Those who gather wealth, first of all, they will be affected when their financial interests are affected, because they already have a living style which is hard for them to give up. Thank you. I'm sure that knowing Mariana, she has the same thoughts about what you've mentioned regarding politicians, Romanian politicians. Anyway, the conclusion is the following. We will be debating this topic, and I think in a offline format, and we'll discuss that. Going forward, I'd like to give the floor to my colleague from RB, Vitayaraku. Hi again. You talk about extended confiscation. Let me say that when the parliament introduced in our law, in our criminal law, the extended confiscation institution, they referred to the decision of the EU 212 from 95 in 2005, and then they also have Directive 42 from 2014 that you referred to, and that established new standards when it comes to the extended confiscation institution. And having looked at this draft law, for sure the author of the draft tried to adjust the extended confiscation institution to the new European standards. Even though this draft is not perfect, it is a good beginning to make good amendments to the institution of the extended confiscation. The agency is the institution which faces first this substantial difference when they investigate the assets of the suspects by conducting parallel criminal investigations. And of course, the competence of the agency that we have now, the powers, those powers, they do not correspond to the list of offenses provided for extended confiscation. In this regard, it is necessary to change this list of offenses as well, which provide for extended confiscation. And I would agree with Ms. Busan when she said that in this list you shouldn't have fraud, because during our investigations that we conduct, very often we would establish that people who do fraud, they have lots of wealth, and even though during criminal procedure, one doesn't establish a direct connection between the assets held with the wealth that they have, even though if somehow we would find fraud in this list regarding extended confiscation, then maybe that would could apply extended confiscation against people who commit fraud. So there are other offenses that we have, then this list has to be reviewed, basically. Also, we have objections regarding this quantum of 20 minimum salaries, monthly salaries established. First of all, this quantum is fluctuating. You can notice that this average salary increases from year to year. And when for instance, if at the time it's about 10,000 lei, then if we establish a difference of 200,000 lei, then with that substantial difference, then next year this difference will not be applicable to the people anymore. And then if the criminal case is already sent to the court, then the judge, they could not even rule on extended confiscation. So we would suggest here to probably have a fixed amount, as it is in Ireland, where you have a 5,000 euro amount, or in UK, I think there, from what I know, was 15,000 pounds. In this regard, it would be better to a fixed amount set. Now, when it comes to the possibility of extended confiscation, ruling it against the person who is deceased, I should mention that, first of all, this is a case of non-rehabilitation, and we welcome this decision to introduce it, because I would actually talk about the status of limitation for the offense, because at least people or heirs of the deceased person should not enjoy the assets of the crime, proceeds of the crime of the defendant. And in case of the status of limitations, if both prosecutor as well as the court, when they order to stop the case, because there was a certain limitation, at the end of the day, the person enjoys these assets that they have gained illegally. To a large extent, these are the objections to this draft law, and of course, this draft law should come together with changing other legal provisions, such as introducing Article 101 first, provided in Article 132 first from Criminal Code. And I also believe we should have changes to the Criminal Procedure Code and to the Enforcement Code as well, when it comes to extended confiscation. Thank you so much, Mr. Raku, for this position, for this presentation. This is a opinion on certain aspects. You talked about fraud. Let me comment make a general comment. In fact, any proposal that is aimed at any normative document has to be justified. Since this is a legal provision which has been in place for 8 years, before promoting some amendments, we should see very clearly how it was applied and specifically look at the statistics. Now, when it is about introducing new offenses, just to understand, look, any offense can be introduced and enlarged, and we could identify different offenses for which we could apply extended confiscation. But we have to understand very clearly why we're doing this, and we need to understand the typology of the offenses which are under the incidence of extended confiscation. You talked about confiscation, right? And I remember you talked about confiscation in a different way. But I remember this as a citizen. Anytime I heard about fraud, it was about some people who actually, borrowed money from other people, and they could not pay back the money. And those people, the creditors, right? They had friends in prosecution. They started criminal cases on fraud. So I saw this many times. I saw this information publicly. So I think that in such situations, you know how our criminal system functions. Unfortunately, oftentimes it actually destroys people, and you end up with this person convicted for fraud, so-called fraud. This was a civil contract where the person just couldn't pay the debt, the borrowed money. So you end up with extended confiscation, right? So I would really want to think that criminal investigation officers will not pursue that, but I allow that they could do this. So that's why I'm saying about typology. We need to understand what happens. What is the typology of these offenses? I understand that we're not talking about classic fraud, but I need to know in how many fraud cases. I mean, we have this classic fraud when a person with bad will, did this. But how many cases we have a person who just, borrowed some money, and the person has a criminal case because the person couldn't pay off the debt. This is what I'm talking about. So this is actually the big danger. But the positive part of it is that we can discuss it. You have a vision of you, sorry, as a representative of the public bodies, and you maybe see things differently. We see things differently. But we need to understand that the criminalization and any fact that the currently is can be convicted for criminally. Previously, it was not criminal, and just in the Soviet times, this was a crime which is called speculation. We don't have this anymore. Things change. So it's important for us to be able to talk about it, and it's good that we had different opinion. And I want that these opinions are taken into account. I think that it would be good to meet offline as well, but it is also very important that any opinion expressed should be based on statistical data, on arguments. I see that Ms. Maria made a comment. It's really, I can give you the floor just to talk about it. Probably it will be easier. I thought that we talked about status of limitations, because this is also an issue regarding how you would apply confiscation when it comes to an offense which already expired. Now, just for the comparison, I put here the link of a decision of the Constitutional Court from Germany from February 10, 2021, last year, when the Constitutional Court from Germany they established the confiscation of assets obtained from crimes if the criminal deeds have expired, subject to limitations, then it should be applied. So status of limitation is not or should not be an impediment to apply confiscation, because confiscation is not a punishment. Confiscation has a different objective. Its purpose is to it's a preventive one for compensation. And the German court stated that all the assets obtained illegally continue to be criminal. So because of the criminal nature of obtaining those. So that is a manifestation of the general rule according to which, in fact, you do not guarantee that the rights obtained illegally would enjoy permanence. So I thought that it is quite appropriate for our today's discussion as a theoretical finding. So if this would be of interest to someone, then they could access it and look at it. Thank you. Thank you so much, Maria, for this. I didn't say it before. Confiscation is applied sometimes against the asset. It's applied against the assets, but not the person. Right? This is a difference. All right. I just wanted to ask whether we have anyone else to take the floor. Anyone? All right. No one wants to get back. Like to talk about it. So thank you very much for participating in this roundtable. I really hope that the discussions we've held today at this roundtable, they would contribute to increasing the quality of the legal creation process, and those responsible for the promotion of drafts of normative documents would listen to these discussions. I think that is the key one. Hopefully, we'll organize these discussions, more of these discussions, so that the legislation, promoted legislation, would be efficient. I thank you so very much. I wish you a great day. Stay healthy and peace. Thank you.